Good afternoon, everybody. My name is Haitham Amin. I go by Sam. I'm an attorney here in San Francisco, California. And I'd like to welcome you to my channel. If you haven't done so, please subscribe, of course, comment, like, follow me on my other social media outlets. And if you have any specific questions, you can always direct message me or leave them in the comment section, and I'll address them at my next video opportunity. Today we will be discussing DUIs, specifically how one can get a DUI without being legally over the limit, or 0.08 BAC, which is blood alcohol concentration in one's bloodstream. And an overview: in California here we have two sections that are usually cited by the district attorney's office when one is suspected of driving under the influence of alcohol, and they are Vehicle Code Section 23-152 Subdivision A, which makes it illegal to drive while impaired. The second is Vehicle Code Section 23-152 Subdivision B, which makes it illegal to drive if one has 0.08 or more of blood alcohol concentration in their system. And the easiest way to explain this, rather than getting technical and throwing out a lot of legal jargon, is examples that I have seen in my practice. And the most common scenario that I have seen here in the Bay Area, San Francisco area at least, is folks that would get in a car accident and they're not legally above 0.08 or higher, so they maybe had one beer, for example, but they are impaired, either ran a stoplight or ran a stop sign or speeding, etc. So the district attorney's office will often allege that this person, although they are not 0.08 or higher blood alcohol concentration in their system, they are still impaired under Vehicle Code Section 23-152 Subdivision A. Again, that makes it illegal to drive while you are impaired. It does not specify that one has to be drunk. Again, people differ with their tolerance, and what constitute drunk or intoxicated or impaired varies from person to person, body weight, height, gender. So it is often common to see one person who is lightweight. They would have one drink and they feel impaired. If that person gets behind a vehicle and drives and subsequently gets pulled over for erratic driving or an accident, they can still be charged with a DUI, not because they are 0.08 or higher, but because they are simply impaired or too impaired to safely operate a motor vehicle. And that is, again, section Vehicle Code Section 23-152 Subdivision A as an apple. The most common DUIs that people are used to is when folks have too many drinks or too many cocktail drinks, too many beers or too many glasses of wine. They usually are above the legal limit. They are usually above 0.08, and that's the classic DUI that everyone is used to seeing or hearing about, and it tells you don't drink and drive. They don't tell you don't, only have one drink and drive. There's a reason why they say don't drink at all and drive, or if you decide to drink, don't drive at all. They don't tell you it's okay to have one beer and hop in the car. They never say that because, again, you can get pulled over for erratic driving if you are driving erratically, speeding, get in a car accident, etc. And you tell the officer, I've only had one drink. That's not going to get you out of trouble because, again, if you're not 0.08 or higher, you're not going to be liable, or rather guilty, under Subdivision B, but you could still be guilty under Subdivision A, which just makes it illegal to drive while you are impaired for any reason. does not have to be alcohol. It could just simply be impaired because you're too tired from having one drink. And if you enjoyed this segment, please, again, make sure you subscribe, make sure you like, comment, and if you have any specific questions, I'll happily address it at my next video. And if you haven't already followed me on my other social media outlets, make sure to check me out on Instagram, Facebook, Twitter, TikTok. And thank you again for spending a few minutes with me. Being the only person that's advocating in the courtroom on behalf of the accused is a humbling feeling for me. I believe in the tenets of the Constitution, which is innocent until proven guilty, and that carries from day one until the trial date.